So, Cristen Martinez, cum laude graduate of Florida State University. We're all Gators fans here, so we're not going to hold that against her.
Oh
But also
no. Not
Juris
our house.
doctorate
We are
graduate.
Seminole fans all day long.
Okay, all right, all
So
right, all right.
you Gators can
Also,
go
Juris Doctorate
elsewhere.
graduate from Stetson University College of Law, extensive legal experience, particularly in real estate litigation, which I think is so key for us. Sometimes you'll hear from experts, gurus, but they don't actually have the on the ground experience dealing with litigation in the courtroom, which I think is so valuable for us because she's dealing with these very scenarios day in and day out for years, right? So it's extremely excited about that opportunity. Kristen's worked for several large firms. She opened up her practice in 2015. Her experience spans residential and commercial real estate litigation, serving a diverse range of clients from homeowners to million-dollar corporations. She regularly conducts educational seminars and trainings, of course, for brokerages and really the whole ecosystem. Again, excited to have Kristen on with us today. She also has a portal called Your In-House Counsel. So that's for real estate professionals, for agents on the line. That's something you'll want to look into through her content. But extremely excited to speak with Kristen Martinez. Kristen, if you could tell us a little bit about yourself, and then we will get into avoiding litigation.
Sure. Thank you. I appreciate that. And I appreciate you all having me here. And I'll throw the link to my in-house counsel service in the chat before we're done here today. But as you stated, I opened my practice about 10 years ago, and we are majority litigation. We do handle some transactional work. We negotiate contracts. We do title work now as well. But I tell you that because it's funny. Since I started my firm, I really wanted to focus on educating the real estate industry on how to avoid litigation. Even though I'm a litigator, and you would think that that would hurt my business, there's still plenty of people out there making plenty of mistakes, getting themselves into trouble. But the kind of joke or saying that litigation only benefits the attorneys is not a joke, because it's true. Like, even if you litigate a case to the end and you win, you've still gone through probably years of attorney's fees and having to take off work and stress, and it doesn't feel all that great, even when the piece of paper at the end of the day says you win. So, and a lot of what I find is that it's the really simple, basic things that people are missing or messing up that get them involved in these lawsuits. So it's not difficult to avoid getting yourselves in these situations, or if you are sued, setting yourself up so that you can get that lawsuit easily dismissed or make sure that your assets are protected. So that's kind of, where I come from with all of this, and kind of why I am so passionate about educating. So like I said, I'll throw that link in the chat for you for my monthly subscription service. It's basically just a way to get you really fast, really cost-effective legal services and advice, because we all know that, everything in real estate you need yesterday, and you often don't have time to wait to have a consultation with an attorney and things like that. So, but Mark, I'm ready to jump in whenever you give me the go-ahead.
So, a quick housekeeping before you do that. So, during our pre-call, Kristen said, "Hey, we get the most out of these calls when it's interactive." So we do have a presentation scheduled for the day. But if you guys have questions that come up as Kristen is talking, feel free to put them in the chat. Keely will monitor the chat. I'll monitor as well. And then Kristen will take some pauses throughout to field those questions from you guys. But yeah, ask the questions as you have them. If something is a little over the head or we need to flesh it out, let's do that. Let's make sure that we learn as much as we can and take advantage of our time with Kristen. So go ahead, Kristen, ready when you are.
All right, so I'm going to go ahead and share my screen, and we will jump right in. All right. So how are we looking on the screen share? Is that how you wanted me to share it?
Excellent. Yeah, that's great.
Perfect. All right. So avoiding litigation as a real estate investor, we are going to cover several different big, and while they can seem like basic topics, most people mess these up. So I think you're going to get some benefit and value from today. Contracts are the biggest thing that get people in trouble. They just are. You're either not using well-drafted contracts, you're not educated or don't have a full understanding about how the contracts work, what your obligations are, what the other party's obligations are, what happens if one party doesn't meet those obligations. So we're going to do a little mini contracts course. I'll try to make it as as less boring as possible, but we're going to do a little bit of contract law here. Disclosures is another big one, especially for investors, that get you guys in a little bit of trouble, or at least allow the buyer of a property to perceive that they have a case, even if they don't actually have a case for non-disclosure. So we're going to look at some disclosure law. Recording of contracts and documents is kind of a more recent thing that is getting investors in trouble. So if that's part of your business strategy and kind of how you structure your deals and one thing that you use to protect yourself, we can talk about the right way to do it and the wrong way to do it to make sure that you're protected. And then the last kind of big picture topics we're going to look at is making sure that you are structuring your business and titling your properties in a way that in the worst case scenario event that you do get tied up in a lawsuit, you do have a claim filed against you, that you are as protected as possible, that it's not that catastrophic outcome where all of your properties, your personal assets, all of those things are at risk in this single lawsuit. So I'm going to give you kind of an overview of why I recommend my structure and then my general ideal structure that I recommend for investors, and then I will leave time at the end for Q&A, but as Mark said, feel free to shout out your questions or put them in the chat throughout, and I'm happy to stop and address those as we go. All right, let's take a look at contracts. I told you we are going to start off very basic, but there's some misconceptions that are out there in the industry that I want to make sure you all are educated on. So first off is, how is a contract formed? We probably all know you need an offer, acceptance, and consideration. One of the misconceptions I see out there, and I see some investors get real creative with escrow deposits, but the consideration in most any contract, but certainly in the real estate purchase and sales agreement, is the exchange of promises between buyer and seller. It is not payment of that initial escrow deposit. So if you have a contract and the buyer never puts, even if you're the buyer, if the buyer never deposits that initial escrow with the escrow agent, there is still a valid and enforceable contract. And if you're using the standard Florida contract, the buyer has committed a material breach of that contract by not timely submitting that escrow deposit. So yes, consideration is required, but it's not as serious as it sounds. The exchange of promises is sufficient for that consideration. Primary role of a contract, again, very basic. It's to memorialize the agreement of the parties, and it's to prevent disputes. So anytime that you are preparing, reviewing, analyzing a contract, reading it to see whether you should sign it or whether you agree with its terms, kind of keep in the back of your mind that the whole reason you're signing this is to prevent disputes down the road. So that means that the contract should be drafted in a way, and if you're using standard contracts, which we'll talk about, the language kind of is what it is. But then you may have some unique terms, some additional terms, some addenda that are more custom to your transaction. You want to make sure that there's only one way or one reasonable interpretation of your contract language. Because where disputes happen is where you have a contract provision that can reasonably be interpreted in two different ways. Where it is, you can always make the argument that certain language can be interpreted any way you want it to. That's why I preface that with the term reasonable. Because where you have a provision that is very black and white, very specific, very express in what it's requiring, it is very unlikely that the breach of that provision is going to result in a lawsuit, because the party on the wrong end of that, hopefully they're going to go see a lawyer, and their lawyer's going to tell them, look, you're in trouble. You need to settle this or figure out a way to get rid of this, because it's very clear that you breached and you're liable. So kind of just keep that in the back of your mind, that you want there to be only one way to interpret the contract language that you are utilizing for your transactions. And then as far as the types of contracts that are available, and I know that a lot of investors get pretty creative with how they like to structure their own deals. So I don't know if the majority of you are using the standard purchase and sale agreement like the FAR contracts, or if you have your own custom purchase and sale agreements that you're using. But either way, the most important thing is to make sure that you are educated in that contract. You know it top to bottom. You know how those provisions work. If you don't know, you are getting that assistance and that professional advice, because a lot of times when people breach contracts, it's because they simply didn't know. Like, this sounds very basic and I make videos on it and I can't believe I have to make videos on it, but I do. But a lot of buyers in the standard contract, they'll miss their financing contingency deadline because they think I can cancel if I don't get approved for my loan. And they haven't read it or understood it to the extent that, well, there's actually a deadline tied to that. So if you don't get approved for your loan past the deadline, you can't cancel. So a lot of it is people just don't know what their contracts say and how they operate. I think for many investors, the standard purchase and sale agreement will work, even if you have to attach to it a customized addendum or something like that. But if you are using custom contracts, make sure they're prepared by a lawyer. I'm not saying that because I want your money so that I can prepare your contracts for you. Get a real estate lawyer to prepare them. They can prepare them in template form so that you can use them for multiple properties, multiple transactions. You're not paying for a new one every single time. But make sure that it is professionally drafted, because once we go through our little mini contract law session here, you will understand that and it can kind of sound ridiculous, but the way that contract language is scrutinized and interpreted is so very specific. Like, typically when we are arguing about a breach of contract in court, we're arguing about either a single, usually not even an entire sentence, like a single phrase or word in the contract that is going to determine which party is in breach and therefore liable and which party is not. So you never want to be preparing your own contracts. Is it legal for you to prepare your own contracts? Yes. You should not be doing it. It is not worth the risk. Most attorneys can get you a custom purchase and sale agreement in, the hundreds of dollars, which I think is well worth it. Other types of agreements that you may be using are joint venture agreements, which, when things are amicable and going great and all your deals have been super profitable and awesome, it's one thing. But you need to make sure your JV agreements are drafted in a way that if a transaction is not awesome, it does not turn out great or profitable, it falls apart, it's a disaster, that each party to that JV agreement knows exactly what's supposed to happen, who's responsible for what, so there are no fights or disputes over that relationship or agreement. Assignments and wholesaling, again, these need to be professionally drafted. They are not complicated documents, but there, again, are certain phrases or words that can blow up the entire thing and result in a dispute that could wind the parties up in court, which is what we want to avoid. Agreements with contractors. So if you are making repairs, renovations, flipping properties, number one, you want to make sure you have an agreement with your contractor. Number two, again, it needs to be professionally drafted. You need to understand how it works. These can look very different from one another, and there's really no ideal perfect way to structure one of these contracts, because what you want and what the contractor wants is going to be opposite. So you're going to have to compromise and meet somewhere in the middle. But these go so wrong so quickly, and contractors have lien rights. So these disputes can be even more catastrophic than, just a simple breach of contract that doesn't come with any sort of lien or attachment to the property itself. And then if you have rentals, I'm really talking about mid to long-term rentals, get a professional lease template drafted for you to use for all of your properties, all of your tenants. The standard residential lease agreement that is available is not terrible, but it's not good. The reason for that is it is drafted in a way to be as neutral as possible. So it is not drafted to favor landlord over tenant or vice versa. It's very kind of bare bones and it's neutrally drafted. You want a lease agreement that is drafted with one goal in mind, which is protecting your best interests at all costs. Now, of course, it has to be something that a tenant's willing to sign, but there are ways to structure your lease agreements that are going to put you in a much better position if you have a problem tenant, whether it be a rent issue or a non-monetary type of default. And it's going to make your evictions a lot more efficient. They're going to move through the process a lot quicker, and it's going to make them a lot less expensive. So lease agreements, again, they seem simple. It's not. Nothing about drafting legal language in a contract is simple. And hopefully this is our little contract law course, mini course. I'm not going to spend too much time on it, but hopefully this will kind of demonstrate to you how courts and judges are required legally to go about interpreting contracts when there is a dispute. And I don't share this information with you for you to kind of advise others or to write this kind of stuff in your contracts. It's really just as you're either, looking at addendum language or reviewing a contract before you sign it, you just kind of have these legal theories in the back of your mind, and you're kind of viewing the contract language through this lens. So first off, we have is the four corners rule. Was there a question?
Before we deep dive into contract interpretation, a couple quick questions on the presentation so far that just come to mind. I think it would be helpful for the group. So one, the contracts that you had recommended before to make sure they were buttoned up, legally reviewed, are those available on your in-house portal subscription, or I guess that's the first question.
Sure, that's a great question, and I get a lot. So there is, on our portal, there is a template library that has several types of documents. There actually is an assignment agreement on there. We don't provide like JV agreements, lease agreements, things like that, because kind of two reasons. One, I really think they need to be customized to not only the person, but the transaction. And two, your agreements are only as good as like you understand and know how to use them. So there are certain investors, and I've had this happen, that tell me, one investor asked me to draft a purchase and sale agreement, and he's like, I need it to all fit on one page. These buyers don't want to sign it, so I need you to fit it on one page. And I'm like, I don't need to make it 12 pages. I don't know if one page is going to work. Other investors want me to be overly thorough, think of everything, and they're fine with 20 plus page documents. So I don't really provide templates of those types of documents because they are so unique and custom. And I want to make sure they're drafted to a level that the investor, the person utilizing those contracts, feels comfortable with and is able to understand and use properly.
Well, let's say we do have template agreements, as you mentioned, right? The JV agreement, the assignment agreement. We have template agreements that have already been legally reviewed for the template at the template level, but then we're inputting, our own, deal specific details. At what point do we need to have that agreement reviewed just to have a professional set of eyes on it before we go to use it? Is there like a certain amount of change, addendum? Like what situation do we run into where it's like, hey, that template agreement probably needs a set of professional eyes on it?
Sure. So if you are filling in blanks of a template agreement, property address, purchase price, and a JV agreement, like split of profit and losses, items that are included in the sale, things like that, I don't think you need, unless you would feel more comfortable with it, I don't think you need a separate or additional attorney review of that. Again, so long as you feel comfortable with the language and you feel like you understand what you're supposed to be populating into the document. Where I would suggest review, and review doesn't have to be this super formal, expensive, time-consuming thing. Like members of my portal, they email me an addendum and say, hey, I got to get this signed in an hour. I just drafted this addendum. Does it look okay? And I'm like, yes, or I'm like, no, here's my suggested changes. So if you're going to add substantive provisions that weren't part of the template, or you're going to like strike through language or add an addendum, that I think should be reviewed. But again, if you're just populating the blanks in the document itself, so long as you feel comfortable with what you're filling in, I do not think that needs separate review.
And then one last question, this is for my wholesalers in the group. You had mentioned consideration. So consideration in this case, of course, is the money that you put up for escrow on a contract. So let's say I'm a wholesaler, I'm assigning the contract, and the investor that I'm assigning the contract to never deposits escrow and doesn't fulfill the agreement. What is the actual legal recourse? I think in practice it's always like, oh, I don't chase them down for 5 or 10 grand because I feel like it's too arduous, et cetera, et cetera. But in your experience, what is the true recourse that we have or the path that we should take in the event that an investor actually doesn't fulfill their commitment on the other end?
So meaning the end buyer doesn't fulfill
Correct.
the
Yeah,
contract.
they don't deposit escrow and they actually don't purchase the property.
Okay. So, I mean, that would be a breach of contract on both contracts, the underlying purchase and sale agreement, and then the assignment agreement, depending on how that's structured. So, like with your assignment agreement, if you're getting paid at the time the assignment is made, then there's no breach because that end buyer already paid you your fee and you're done. If you're getting paid at a closing, at that point, there would be a breach of that as well. Of course, the answer as far as whether you have a claim is much different than the question or from the question, does it make sense to pursue the claim? Like you said, 5 or 10,000, you're at 10,000, you're probably on that borderline of maybe it makes sense, but still probably not. But they're, just kind of generally answering the question, that would be a breach of both the underlying purchase and sale agreement. So that would be a cause of action that the seller has against the end buyer, and potentially to that assignment agreement between the investor and the end buyer.
Thank
Can
you.
I
I'll let you
piggyback
continue.
on that question? So I was thinking the same kind of thing. I'm an agent also, and so I think that's important to note because the way that we've always been taught, or I've always been taught to interpret contracts, are that the buyers agree to put their escrow in and whatever that predetermined time frame is, right? And if they don't, then we just notify the other party that we're not going to be moving forward in the transaction. But a cancellation and release of escrow is not necessary because escrow was never in fact submitted. So the contract at that point just becomes a wash and it isn't really canceled. Is that in fact accurate based on the terms of the contract or no?
So if the buyer doesn't submit escrow, the seller at that point can terminate the contract based on buyer's breach. The buyer is in breach of contract at that point, and the seller has the option to terminate, or the seller can choose, I'm going to keep going on the contract. They're just having some difficulties. The wire got messed up, whatever it may be. Hopefully they pay it in the next few days and I'm going to continue to perform. But the contract does not cease to exist or disappear or anything like that once that escrow deadline is missed. It's still enforceable, but the seller does have the option to terminate it. And then, so the seller would have to send a written termination, but a release and cancellation of the escrow isn't really applicable there because the escrow agent doesn't have it. So at that point, the seller would have a claim against the buyer for the amount of the escrow.
Okay. And then obviously as an agent in our Florida forms, we have access to that release and cancellation for specific escrow, right? But is there also some type of Florida form that we would or should have access to that's related to the seller just dissolving the contract?
There's not a standard form that I'm aware of where the seller is terminating the contract, but it's not on that release and cancellation form where it has the lines where you designate where escrow is going.
Gotcha.
You could use that form and just not fill in the escrow part because it's not applicable. But all the contract requires is written notice from seller to buyer that they're terminating the contract. That could be an email, that could be, any type of form you want to use.
Okay, awesome. Thank you.
You're welcome. All right, so moving on to our contract law lesson. So the first rule is called the four corners rule, and simply that just means that the only thing that counts is whatever's in the four corners of your contract. Now that includes amendments, addenda that are fully executed, but nothing else counts, nothing else can be considered by a court in interpreting the contract. So the, email communications when you were negotiating the contract, prior discussions, text messages, nothing like that can be considered unless there's an ambiguity in the contract. So if there's something that's ambiguous, a court can't determine what the parties intended based on the language in the document. At that point, they can look to external sources. But the general rule is whatever's within the four corners of the document is all that can be considered. Next is specific terms are always going to control over general terms. So I always use the appliances that are included in the conveyance as an example. So if you have a contract term that says all appliances convey at closing, and then after that, you have a provision that says the refrigerator and microwave convey at closing. And let's say there's more appliances than that in this particular property. That second provision is going to control. So only the fridge and the microwave will actually convey, because it's more specific than the general term that said all appliances. And clearly, you can't enforce both provisions because they contradict each other. So keep that in mind as you're reviewing contracts, as you're filling them in. Specific is always going to control over general. This next contract rule is a Latin term that I'm not going to try to pronounce for you. It kind of piggybacks off of the specific versus general terms, but it just simply states that the inclusion of one thing means the exclusion of another. So if you, again, take that appliance example that I gave you, if the contract says the refrigerator and the microwave convey, that automatically means that every other appliance is excluded from the purchase. By including those two items specifically, you are thereby excluding everything else. This next one is important. The contract is always construed against the drafter. So I'll tell you what that means, and then we'll talk about standard contracts. So whoever drafts the contract, or whoever's real estate agent or attorney drafts the contract, if there's an ambiguity in that contract, the benefit of the doubt is going to go to the other party, the party who did not draft the contract. When we are talking about standard contracts, it's whoever fills it out. If you're using a FAR purchase and sale agreement, whatever investor or whatever agent fills it out, if there's an ambiguity in that language that was populated into the standard contract, it is going to be interpreted against that party whose agent or whose representative actually populated or filled in the contract. So that's one thing to make sure you keep in mind as well. Piggybacking off of talking about standard contracts, unique terms are always going to control over standard terms. So the pre-printed language in a standard contract, those are your standard terms. Your unique terms are the terms that you are filling in, that you are populating. So the property that's included, the purchase price, the escrow, the financing amount, the inspection period, any additional terms, any addenda, those are all unique terms. So if those contradict what's in the pre-printed language, the unique terms are going to control. Most recent terms also control. So if an addendum signed after the original contract contradicts that contract, the addendum language is going to control. And finally, integration clauses kind of wraps this back around to our four corners rule. It just means that a court cannot consider any other agreements or writings between the parties other than what's in the contract itself. Hopefully that is just a reminder for you and you're not hearing or learning of that for the first time. But the parties, and I put an asterisk here, the parties' intent. So if they meant one thing, but the contract says another, it doesn't matter. The contract will be enforced. The parties' course of dealing. So let's say you're an investor that, works with the same investors all the time. You've done dozens of transactions together. They've all been done in the same exact way, but the current transaction was done differently, but not intentionally. You both just messed up on the contract. You cannot argue to the court, well, the last 20 transactions we did this way, so that should be evidence that we meant for the current transaction to be done that way as well. A court cannot consider those things. So again, make sure your contracts include everything and they are as specific as possible. Questions on any of this before I move on? All right. I've sufficiently bored you all with contracts, so if there are no questions on that, we will move on to disclosures. So disclosures are one of the most litigated areas of real estate law, and it's a unique topic when it comes to investors, because oftentimes when you're selling a property as an investor, you haven't actually personally occupied that property before. So let's take a look at just general disclosure law, and then we'll tie it into how it relates to investors specifically. So if you're using the standard FAR bar contracts, you should be familiar with paragraph 10J, which is essentially the legal requirement to disclose defects as a seller. 4 elements have to be present. The seller has to have actual knowledge of the defect prior to closing. The buyer cannot have any knowledge of the defect. So if an inspection report discloses the defect, if the neighbor told the buyer that the house flooded prior to closing, but the seller never disclosed it, doesn't matter. Buyer found out prior to closing. So buyer can have no knowledge. The defect cannot be readily observable, meaning it has to be a hidden defect. It has to be something that the buyer could not discover or find out on their own, but for the seller disclosing that defect to them. And the final element is that the defect has to have a material effect on the value of the property. That is going to differ based on each property, the value of each property, but we're not talking about tiny cosmetic type issues. All 4 elements have to be present before a seller has any duty to disclose. And if you're not using the standard contract, or if you're using an addendum that essentially removes this paragraph 10J from the contract, so you're intending to not make any disclosures, this same disclosure requirement on sellers is part of Florida's common law. The seminal case is the Supreme Court case of Johnson v. Davis from 1985, which basically recites those 4 elements that I just told you about and that are present in the contract. So there's no getting around, there's no contracting around this duty to disclose, because it exists in common law, whether or not it exists in your actual contract or not. So we're going to take a look at what could happen to you if you don't disclose something that you should have disclosed. Before we jump into that, I just want to address the situation when you haven't actually occupied a property. I will see the seller property disclosure, not filled out, but just written across the top, like sellers never occupied the property. I've seen addenda that investors attach to their contract stating like, seller has never lived there, so they're not making any disclosures or representations about the property. That type of language is not going to protect you as a seller from a defect that otherwise should have been disclosed. So the fact that a seller has never occupied a property does not equal the seller has zero knowledge of any defect that may have to be disclosed. I always recommend to at least go through the exercise of filling out that seller property disclosure document, reading all the questions, really thinking about like, do I have knowledge of any of this stuff? To be able to determine, number 1, what types of things am I supposed to be disclosing? And number 2, do I actually have knowledge that I didn't realize I had? A lot of times when you are doing repairs, renovations, you have tenants calling and complaining that the roof is leaking or whatever the case may be, you actually do have knowledge, or you have records of your knowledge of things that maybe you wouldn't have otherwise thought of or you forgot about. So don't assume that you can just say, I've never lived there, so I'm not providing disclosures, that is going to protect you, because it does not. If you do not disclose something that you should have disclosed, the buyer may have claims against you for breach of the contract if it's in the contract. If it's not in the contract, fraud in the inducement and fraudulent misrepresentation or omission. The remedies available are their monetary damages. So you didn't tell me about this roof issue. I had to buy a new roof for $20,000. You owe me $20,000. Rescission is the buyer's other remedy, which means that after closing, if there was some probably major defect that was not disclosed that should have been, The buyer can file a lawsuit not asking for money, but asking the court to essentially unwind the transaction. So buyer saying, I'm giving you back the property, you're paying me back all the money, plus my inspection fees and closing costs, everything, so that both parties are put in the same position they were in before the contract was ever signed. That can be a very, I don't know if catastrophic is the right word, but it could be a very significant consequence to not disclosing. So I know, we don't want to disclose, we don't want to scare buyers, we don't want to, give buyers ammunition to negotiate a lower price point, but it is never worth it when you think about what a lawsuit could look like or could cost you. And then the prevailing party does get their attorney's fees paid or reimbursed by the non-prevailing party. So if you get sued and you lose, not only do you have to pay them all their damages, not only have to pay your own attorney, but you're going to have to pay them for their attorney's fees as well, which is extremely significant. It's likely a very significant number. So what started off as a $20,000 roof bill could end up, in the six figures once you account for everything. So I don't say this to scare you. I just say this, just disclose it. It's not worth it to take the risk. And if you're ever in doubt whether you should disclose something, ask an attorney, but you should probably just disclose it anyway. Go ahead.
I was gonna say, so two questions here. So first, there's one in the chat. How long after closing can they go back and sue you?
For monetary damages, for money, 5 years. For rescission, 1 year.
Okay. And then I have a question about disclosure or kind of duty to disclose. So now as an investor, you've never lived in the property. You come in, you start working. There's always like neighbors that come around and they've got all the lore of the house, right? So how much do you have to disclose if those things are also just not readily visible to you? So just for an example, let's just use flooding because I feel like that's something that keeps coming up right now with everything that happened in Tampa. So let's say that you go in to purchase a home. There's no evidence that the house flooded. Like obviously being, you're having contractors look at it. They don't see any damage, any evidence of flooding, but you have no information about whether it did or not. And a neighbor comes over and says, oh yeah, this house had a couple inches of water in it during the storms. Like as an investor, am I required to disclose that even if we don't know about that and we're not seeing evidence of that, right? Is that something that I now need to disclose because somebody else told me that?
So you do know about it because you were told it. So you do have that knowledge. Now, the next question is there anything wrong with the property? If everything was properly gutted and repaired and dried out and remediated, maybe there's, no defect that's present. The problem with water is mold can grow after a period of time behind walls, underneath floors, and nobody knows about it. You can't see it, you can't smell it, you don't know it's there. So typically, when you have a defect that is properly fixed and repaired, you no longer have to disclose that that defect existed. However, my advice is when it comes to water, always disclose it. And the disclosure can be as simple as the neighbor told me this. I have no idea if it's true or not. We have seen, like you said, zero evidence, zero issues. We've done moisture tests, we've done mold tests. They've all come back clean. Here's that information. But we were told this because that same neighbor is going to run over to the buyer the minute they close and move in and tell them the same thing. So that's how I would handle it. If you're 100% positive there's no mold and there's no possibility that mold grows as a result of that flooding event, then you technically don't need to disclose it, but that's obviously a difficult place to get. So,
but essentially if it's not water, but essentially if somebody who seems to be familiar with the property tells you of something that they knew that happened in the property, then technically now you have knowledge of that, whether it's true or not, or you just, kind of don't know, you're still gonna just be proactive in covering your butt and, disclosing it.
Yeah, I mean, it depends on what it is. If it's something that you could go in and verify and bring a contractor out to make sure that, whatever it was is not an issue anymore, then you may not need to disclose it. But it really depends on what it is and whether it falls within those 4 elements that we spoke about.
Gotcha. Thank you.
Sure. Any other questions before I move on?
I have a couple follow-up questions.
Okay.
So could you give a couple examples of like lawsuits or people that have gone back and said, hey, I'm suing you for X? And then isn't it part of the buyer's responsibility to have an inspection? Like, where's the gray line? If they can go back a year or 5 years, shouldn't they have identified this during their inspection? Because, like, I have a property, the neighbors told me that it did not flood. So I'm saying, I don't know, I don't live there. Neighbors didn't flood. So at what point does, like, it's on the owner's the new owner's responsibility? Because, like, what if they're mismanaging the property, they're not taking care of it, they're not upkeeping the maintenance on it, and then year 4 they come around and say, hey, like, here's an issue, I think it's your fault.
So keep in mind, so yes, the buyer does have the great responsibility of researching, inspecting, performing due diligence on the condition of the property. The only thing the seller has to disclose is defects that the buyer couldn't discover through proper, thorough inspections. If your home inspection report says, hey, the moisture reader read a little bit high here, I would suggest a mold test. If the buyer doesn't follow up with a mold test and there's mold, buyer can't sue. So it's a very limited scope of defects that a seller would have to disclose, and it's only intended to capture those things that, again, the buyer could not have discovered through an inspection, through walking through the property, through inspecting the public records, things like that. I don't know that I have time to get into lawsuit examples. There are many of them. A lot of them deal with mold and water issues. We just had one where the square footage was misrepresented. And the question was, is that a hidden defect or is that not a hidden defect? They kind of run the gamut as far as types of defects that we see. So if we have time at the end, I'll definitely give you some real life examples of that. But I want to make sure we get through the content. All right, so finishing up on disclosures, this one is often missed. It is a permits disclosure. It is in the standard FAR/BAR contracts. So as a seller, you have to disclose any work that you have knowledge of that was not properly permitted or that permits were not properly closed out. If not, those same claims and remedies could apply against you. And then keep in mind the new flood disclosure form and requirement. It became effective last year. Starting October 1st, it is going to be an expanded form. So it's going to broaden the types of flooding events that have to be disclosed. And it's not just going to apply to sellers, it's going to apply to landlords as well for new leases signed October 1st or later. So make sure that you have that document. It's a standard Florida Realtors document. The updated one will be available October 1st, and make sure you're providing that in all sale transactions starting now, and all lease transactions starting October the 1st. All right, next thing that gets investors in trouble is recording purchase and sale agreements, assignments, memorandum of interest, whatever you want to call it. I've seen it called several different things. Florida law prohibits any agreement for purchasing or selling real estate from being recorded unless there's a provision in the agreement authorizing the recording of it, and the seller has signed the agreement in front of a notary and 2 subscribing witnesses. That is often not done, and these are getting recorded anyway, and investors are getting sued and having to pay a lot of money for harm to a seller. I understand the intent is to stop them from selling it to somebody else. If that is part of your strategy, you have to make sure you have that language in your contracts and you're having the seller's signature be notarized and witnessed on those contracts. Same applies for assignments of any such agreement. So an assignment can't be recorded unless the underlying contract that is being assigned complies. So it has that authority in the contract itself to be recorded, and it's signed by the seller in front of a notary and 2 witnesses. This is one we deal with a lot. It is very easy for us to file emergency motions and get in front of a judge within a week to dissolve whatever notice or document was recorded prior to closing. But then you're going to be oftentimes hit with liability or money damages that you have to pay. So not worth it. Make sure you're doing it right if this is part of how you structure your transactions.
So just to dumb that down for everybody a little bit, it's what we're talking about is encumbering the title, right? Correct me if I'm wrong here, but essentially,
Exactly,
and you see
yes.
this a lot with like, I mean, I think wholesalers do it often. Investors, I think some of it is obviously shady. Some of it is probably just bad education that they were given about what they should do to kind of protect the deal for themselves, right? And so what we're talking about is essentially somebody going and recording this information against the property, which encumbers the title so that the seller then can't sell the property to anybody else. And what she's saying is you cannot do that unless there's these very specific things in place, which is very rarely done, right? And if you do it, it's very easy for that to be wiped out and for you to be in big trouble and be sued. So specifically wholesalers, I would say, but also applies to investors. If you're learning this anywhere, being told like, oh, here's a strategy that you should do, you should not do it because it's going to cost you money and get you in trouble, unless you're doing it the right way. But again, most of the time that's not the case.
Yep, exactly. Thank you for that recap. So our last kind of two topics are kind of how to structure your business and liability protection. I know we're kind of running low on time, so I can either skip that and just take questions, or we can go through it. Mark, what would you prefer, or anybody else, what would you prefer I do?
Yeah, I say we cover it. If you want maybe abbreviated version, but I think it's important.
Okay.
Any
And
questions
I'm
for me?
happy
Put
to
them in the
stay
chat now,
longer as
Liz.
well. I'm not
Yeah,
limited, but I want to be respectful of you all's time as well.
sure, sure. Yeah, let's go for it.
All right. So liability protection and asset protection. What I mean by that is if you get sued with regard to a specific property, the goal is that any liability, any final judgment that is entered in that lawsuit affects only the property where the injury, the liability occurred. And it doesn't affect any other properties you may own. It doesn't affect any of your personal assets like bank accounts, wages, vehicles, boats, anything like that. So how do we do that? I'm going to talk about LLCs and I'm going to talk about land trusts. When I talk about LLCs, you can substitute in any of the other corporate entities, and all of this applies as true. Corporations, partnerships, limited partnerships, whatever you want to insert in here. For liability protection purposes, they all work the same. So LLCs do limit liability for the owners of the company, meaning if the company messes up and gets sued, the lawsuit's filed against the company, but the owner's personal assets are not subject to that lawsuit. However, you see in bold and all caps at the bottom of this slide, beware of the corporate veil. So that liability protection will only protect the owners if all of the corporate formalities are followed. So you have a proper operating agreement. You're having regular meetings where you're recording minutes. You are not commingling funds and expenses of the business with those of any of the individual owners of the business. You have to be very diligent and careful to comply with all of this, or that liability protection I just spoke about goes away. So that is one big risk of using LLCs or any other type of corporate entity, is you have all these things to comply with, and if you don't comply with them, you don't get the protection it offers. Avoidance of probate. So with a corporate entity, you can put in your operating agreement or your shareholder agreement, if something happens to me, I want my interest in this business or the business assets to go to my heir, and you can name them, and then they avoid probate upon your death. No partition between co-owners. So when you own property with another person, if at any point in time both of you disagree on what to do with the property, whether to sell it, whether to keep it and rent it out, whether to do a big renovation or repair. If you ever have a disagreement with your co-owner, each co-owner has a right to partition, which means either party can file a lawsuit and say, hey, I don't want to own this property with this person anymore. Court, I want you to force the sale of the property and just split the money up between us. And there's no option to retain that property. That's not available with an LLC. Keep in mind that both this benefit and the avoidance of probate requires an operating agreement. One mistake I see is people run to Sunbiz, they take 5 minutes, they pay $125 to set up their LLC, and boom, they think they're protected. You are not. There's a lot more that goes into it than that. And an operating agreement is one thing that you definitely need to make sure you're protected and to make sure that you have all of these benefits it provides. Ease of transfer, meaning if an LLC owns property, you can simply sell or assign the shares in the entity to another person or another entity versus executing a formal deed that transfers title. And there may be certain tax benefits for the different types of corporate entities. That's a discussion to have with your tax professional. But here are the general benefits of an LLC. Let's compare and contrast that with the benefits of using a land trust. So a land trust does provide liability protection for the beneficiaries or the owners of the land trust. Keep in mind, a trust is not a corporate entity. So you can commingle. There are no meetings or minutes that you have to record. There are no corporate formalities, excuse me, that you have to follow in order to maintain the benefits. They will always be there. Even if you mismanage everything, you're still going to have the protections that the trust provides you. So they're much more user-friendly than corporate entities. You still get the no partition by co-owners. You still get avoidance of probate. You do get anonymity with land trusts. So the beneficiaries, their names are not publicly available anywhere. Like with corporate entities, they're available on Sunbiz. With a land trust, they're not publicly available anywhere. With a corporate entity, if you want anonymity, you have to incorporate in a state that provides that. Florida does not. There's no annual fees for land trusts to keep them active, no renewal fees, anything like that. Not subject to creditors or judgments of the beneficiaries. So when we talk about asset protection, we talk about like inside and outside asset protection. So inside is if the land trust owns a piece of property and a lawsuit is filed against the land trust, that liability doesn't get to the beneficiaries. Conversely, if the beneficiaries are out driving and they get in an accident and they kill somebody and they get sued, that lawsuit does not affect the land trust. So it works both ways with a corporate entity and with land trusts. Other benefits that are unique to the land trust is there's no property tax reassessment for transferring property into a land trust so long as there's proper language and the land trust is structured properly. And the beneficiary, if it's your primary, can maintain homestead, which probably doesn't apply to this group, but a question that I get asked a lot. Umbrella policies, you always want to have them because if you get sued, ideally, the claim is covered 100% by insurance and they pay it out and you go on your way. The asset protection entities that I just spoke about are kind of your plan B. Like there is no insurance to cover it, or the insurance company only approved or is covering a portion of the claim. Now we need to make sure that while the property can be accessed for that liability, none of your other properties or personal assets can. So even though you're structuring things properly, you still want to be as insured as possible. And here's what I wanted to get to as far as the recommended structure that I have for you. So do not hold title to property in your individual name, ever. That is a huge mistake. Never do it. It never makes sense to do. Why? Because if something happens, you get sued and everything you own in your personal name could be taken, garnished, seized, foreclosed to satisfy that lawsuit. Never a good idea. For business assets, you want those to be in a corporate entity. So how you operate your business, the income you get from your business, so your bank account, if you have any physical business assets, you want those to be in a corporate entity. Any real estate you own, you want those to be in a land trust. And then if you own multiple properties, multiple pieces of real estate, what you can do is you can set up a second or a separate corporate entity to serve as a manager or a management company for all of your land trusts. This allows you to manage all of your properties from the same place, from the same bank account. So if you have 5 properties and 1 month you're short for a property, you can pull funds from income from other properties to cover the bills, a repair, whatever it may be. With other structures, you can't do that because that's called commingling and you lose the protection. So for ease of management, if you have multiple properties and their own separate land trusts, you can have one management company LLC that manages everything from one place. We can go ahead and open it up for questions on that. That was the bulk of what I wanted to get through it. I'm sorry I had to rush through it.
Great. Oh, awesome. Thank you so much. We do have one in the chat, and then I'll open it up to the group. And Kristen has a hard stop, so we'll try to be brief. So Ari, if you want to go ahead and ask your question, if you can jump in. I'll read it. Do you need to record the OA anywhere? If two parties own a property in an LLC, can you buy just one owner's interest in Florida? I'm
Yes.
sorry, those
So
are two separate questions.
two questions. So the OA, the operating
so the first
agreement.
is, do you need to record the OA anywhere?
Yeah, no, so that does not get recorded anywhere. The SunBiz will have publicly available the articles of organization, so it'll show the registered agent, the owners of the LLC, all of those details, but the actual operating agreement is just a private agreement between the owners of the LLC.
Yeah, what's going on?
The next is, if two parties own a property in an LLC, can you buy just one owner's interest in Florida?
Yes. So that would require an addendum or amendment to the operating agreement to basically reallocate or assign those shares or those interests of the one owner to the new person coming in.
I have a question. Hey, thanks for joining. It's been very informative. My question goes for the land trust, and I know you mentioned that it doesn't trigger a reassessment on the property. Can you talk a little bit more about that? I thought that even with the LLC, it might do something like that.
Sure. So with an LLC, it does trigger reassessment. So what I mean by that is, and it really only is applicable to where you own property, maybe in your individual name or through a different entity for a period of time, and then you want to put it into an LLC or a land trust. You don't want the property's value to be reassessed so that you're paying taxes on the current value versus the original value plus your 3 or 10% increases per year.
Right.
So with the land trust, so long as control of the property is not changing. So if you're the sole owner and we put it into a land trust where you're the sole beneficiary, you still have 100% control. There's no tax reassessment. With an LLC, no matter what you do, taxes will be reassessed.
Thanks. And then one more question about the land trust there, and I'm sure it's a contractable detail with my mortgage. It's in my personal name right now for one of the rental properties, and I'm wondering if I transfer to a land trust, might that trigger a due on sale clause or something like that? Or any thoughts on that? I'm sure it's specific to that agreement, though.
So, I mean, I guess I can only speak to like standard mortgages. So if you have something super unique, we need to look at it. But
No, it's standard,
that's another benefit of land trusts is there's a federal law that prohibits your lender from triggering that due on sale clause when you are using a revocable trust and the owner/borrower is the sole beneficiary of the land trust. So as long as we're keeping quote unquote ownership the same, control the same, your lender cannot call your loan due in that instance.
So why would anybody not put their, oh wait, is that?
I don't know.
Because
I
is
can't
that
figure
the
that
same
one
for
out.
like your primary residence as well?
Yeah, so it's great for your primary. You get to keep homestead, which
Sweet.
is unlike any other entity. So I don't know why every person doesn't have their properties in a land
Gosh, well,
trust.
we're going to be calling you after this Zoom to get ours put in a land trust immediately. We have 2 more questions in the chat.
I want to be mindful of Kristen's time. I know she had a hard stop at 1.
I'm okay if you guys are actually. So
yeah, absolutely. Sure.
Awesome. Thank you so much
okay.
for that.
Really appreciate that. I think we have a few more questions in the chat. So Ari had a follow-up question to the, if two parties own a property in an LLC, can one buy out the other's interest? I think his follow-on was, do both owners of that LLC have to agree to the partial sale?
So that's going to depend on what's in the operating agreement. That's going to dictate how that can happen, how one party can sell their interest. Most all operating agreements that I've ever seen do require the other party's consent. Yes.
And
There was
then
one more I
he
think
also
is
has like,
interesting is
yeah, is Florida land trust revocable or irrevocable?
It is revocable. So they're super flexible, easy to use. You can change them, amend them at any time with simple signature from the beneficiary. They're really flexible in that way.
no other questions from the group. Take advantage, guys.
I guess one question, how long does that process take to set up the land trust?
It really just depends. Right now we have a pretty large volume of them, so we're quoting 30 days for the entire process. We certainly can get them done more quickly. And if you are under contract to purchase a property and you want to purchase it into a land trust, those will obviously get priority and we'll make sure we have it done in time for closing.
And what is the cost to do that through your firm?
So we charge a flat fee of $1,500 for the package. So that's going to be creation of the trust. That's going to be the deed. That's going to cover your recording fees. And then that's going to cover a certificate of trust as well.
That per property?
Yeah. So assuming you're doing a separate land trust for each property, which you should, that is per property.
Thank you.
Sure.
Anything else? So I have one quick ask of you, because this is always helpful when we do these at the end. So, three biggest common mistakes that you see among the investor community in their projects, in their deals, in their assets that they hold. What are the three common mistakes that you think we should try to avoid or that you see most commonly?
We've probably covered all of them already. The top one, hands down, like no questions asked, is not using professionally drafted or reviewed contracts. In the investor community, especially, we see contracts you get from different like seminars or conventions that non-lawyers or people that do it in another state are giving you their templates and you're trying to use it here in Florida. You're getting them off Google, you're creating your own. Usually that ends up in a disaster if a dispute arises. So that's hands down the biggest one. The second one I will say is probably just more of a broad one, like lack of education. A lot of times when investors get sued, it's not really because sometimes they are, but for the most part, they're not some fraudster that's like trying to, trick the buyer or commit some sort of great fraud. They either made a mistake, they didn't know, they didn't read the contract, whatever the case may be. So that gets a lot of investors because there's so much to know. As an investor, there's so many different things, not just from a legal perspective, that you need to know that it's tough to keep on top of it all. But just kind of lack of education, I would say, is the second one. The third one, I don't want to like regurgitate what I've already said. Disclosures is a close next one. One thing I didn't mention that I think is important that at least a lot of investors who are newer or just starting out skip over because probably cost, but not setting things up right on the front end. So not getting your team of professionals, not getting professional tax advice and financial advice and legal advice, and then not making sure that you're setting up your structures up front. Like usually when I represent investors, they do it wrong, they get in trouble, and then they come to us to fix it and help them clean it up, which we can help with, but that's a much more expensive and frustrating process than if you would have paid, a few $100s or a couple $1,000s, depending on what it is, to set up everything properly up front. And I get it from the financial perspective. So, but I would say those are probably the three biggest things.
I see that you hopped on. Did you have a question before I close this out? No? Okay. All right. So if you
I have
can,
a
just take a quick
question.
second.
Sorry, Mark, I
Right,
had
please.
to unmute.
Shoot, go
So
for it now.
my question is, do you offer like a consultation or service of any kind for investors that want to figure out the most effective way to structure their, I guess, status, like the most effective thing for them to do, whether they're looking at doing like new builds and they're only building new homes and reselling those, or if they are flipping, or if they have a rental portfolio? Like, do you offer a service where you can sit down and go through, okay, this is the most effective way for us to set you up, and now we're going to set you up and this is what it's going to cost you?
We do, yes. So we offer several different types or lengths of consultations. For something like that, we have 4 different attorneys in my firm. For something like that, I probably would recommend you have it with me. I have the most experience with investors, but I would probably recommend either 30 minutes or an hour consultation for that. But you can send over everything ahead of time. Like, here's the contracts I'm using, here's the properties I own, here's my general business structure, so that I can come prepared. And then, yes, we can sit down together and come up with a plan. And then we can quote you like flat fees for everything that we're going to recommend, so that you
Okay.
have that information all laid out for you.
Okay, and what's the cost of that consultation?
I think it's 200 for 30 minutes and 400 for an hour.
Okay.
I think that's right. Shoot me an email and I'll respond with our fee schedule that has everything on it, but I think that's accurate.
Okay, thank you.
You're welcome.
So I'll close this out here in a minute, but along that same vein, if you can tell us a little bit about your in-house counsel portal, maybe what the cost of that is and what the service entails, and then we'll close
Yeah,
out.
so that's actually a great segue. So with the in-house counsel portal, you get access to the portal itself. It kind of looks like a Facebook feed in the middle. So you have access to the whole community. You can ask questions, discuss things like that. And then you have access to all of our events. So every month I do a live class on real estate related type topics. Every month I do a live legal roundtable, which is just kind of an informal Q&A session. Every quarter, I do a live 2-hour continuing education course if you're a realtor. If you're not, the information's still good, but the credit wouldn't apply to you. You also have access to our class library, where we've recorded every past class that I've done, and they're all posted there, so you can see all the trainings and topics. And then we have our template library, which has several documents, agreements, addenda, things that there are not standard like FAR/BAR or Florida Realtors forms for you that you really shouldn't be drafting on your own. So those are available to you in Word template forms so that you can, download them and use them. Our basic plan includes all of that, and that is a $50 per month fee. Your first month is free, so you can always join and check it out. And if you don't find it valuable, you can leave. Our premium level is $99 a month. You get all of that in addition to, you get 2 free consultations per month with me. So you could do your business strategy, or if you get in trouble, you can ask me how to handle, or if you're, filling out a contract or you have contract language you want me to review, you can shoot that over and count that as one of your consultations. You can also gift those consultations to clients. So usually that applies more to real estate agents, but if you have a client that's in a dispute or someone didn't close or whatever it is, that's an additional service you can provide to them, that they now are set up, you've already paid for it, and they have direct access to an attorney as well. And that one is, the first month is free as well. So if you click that link, you can go ahead and sign up, and there's no commitment or anything like that you have to sign up for. You can check it out and see if you find it valuable.
That's huge.
Unbelievable
That's
value.
huge value.
I'm signing
So
up
the
today.
better
That's
question is,
amazing.
why isn't everyone a part of my
Sign me
online
up.
subscription?
Why doesn't
which-
everybody have their house in a land trust?
I don't get
Why
it.
does everybody not
Exactly.
subscribe to the in-house counsel? That's the question.
Agreed.
Well, Cristen,
Amen.
we're so grateful for your time. This has been an amazing masterclass, and thank you for cramming it all in an hour. I'm sure we could unpack it for 5 hours, but that was so informative and helpful. We truly, truly value your time. If we need to reach out to you to look into services, consults, or if we just want to stay connected with you, how do we do it?
Yep, I'm going to put my email address in the chat right now. And you can just email me directly with questions. I can get you to the right place if if you want to sign up for in-house counsel or whatever information you need. But I am sorry I had to rush the content. I will plan that better moving forward. But I have a ton more content that I think would benefit you guys. So if you ever want to have me back, hint, hint, I would be happy to do that.
We'll definitely
Absolutely.
connect with you on that for sure.
Sure.
Yeah.
On behalf of the whole Above Asking community, thank you so much. We look forward to connecting with you again, and we'll be following you on all of your platforms and
Yes,
soaking
thank
in all the
you.
knowledge.
Yes.
I
Thank you
appreciate
so
you guys.
much.
Thank you so much.
Yep.
Thanks for the great questions.
Thank you.
Thank you.
Thanks. We'll
Thank
talk
you.
soon.
Bye-bye.
Bye, everybody.